your bond could be revoked entirely. It would, at a minimum, start at $10,000. Any questions? Okay. Attorney Anderson?
Nothing further, thank you.
Okay, thank you. Then, Mr. Black, you're free to go to the door and tell the jail that you are finished. Good afternoon. Would you be Mr. Cleaver?
Yes, ma'am.
Okay. Now calling the people of the state of Michigan versus... Okay, sir, state your name for me.
Waylon Cleaver.
Jaqueline?
Yes, ma'am.
Okay, Jaqueline Lavelle Cleaver, Police Agency Report Number 24-15945. Can I have appearances for the record, please?
Ashley Peltis for the people.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Cleaver. Your Honor, we waive formal reading, stand mute, and reserve our bond argument.
Thank you. Did you say you were waiving formal reading?
Yes, Your Honor, we reviewed the complaint in this one.
Okay, for some reason I thought you didn't have this one.
No, it was a different one, but I believe that it's going tomorrow. It was Cuevas that we didn't have.
Ah, okay. Sorry. All right then. Mr. Cleaver, you have the following basic rights. You have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is, before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. So, any questions about your rights?
No, ma'am.
Okay. Because this case is considered a felony, you have the right in this matter to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that the case is strong enough, it will be bound over, that is, transferred to the circuit court, which is where your actual trial will take place. Any questions?
No, ma'am.
Okay. Prior to that, the court will schedule a probable cause conference that is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be on August 28th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Okay?
Okay.
Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So, can the attorneys address bond, please?
Your Honor, in this case, the people are requesting that the court order drug testing. I would ask for at least intermediate, if not high supervision at community corrections, testing at least one time a week. In this case, Your Honor, the defendant is charged with possession of a controlled substance less than 25 grams and 2 other counts as well. I'll note for the record, the defendant is currently on probation for possession under 25 grams and assaulting or resisting or obstructing a police officer. He was sentenced to 24 months of probation starting in January of this year, so he is currently still on probation for that charge. I do believe the date of this is before he was placed on probation, so this is an offense that happened before that. However, it is still concerning. I do note that he has several prior felony drug convictions, and I would request that the court consider all of that when making its bond determination. We do not have a current monetary amount for the bond, but are hopeful to see a recovery for this person. Thank you.
Okay.
Your Honor, in this matter, we'd ask for a personal bond. My client is a father of 4. This is a non-assaultive charge that occurred. I have an offense date of September 24th of 24, so it's almost a year old. If the court is to order any drug testing, we understand that he would need to enroll at community corrections, but would ask if the court can note or a comparable testing facility, since he does reside in Mount Morris, so something a little closer to his home. Nothing else is holding him in custody, Your Honor, and again, we'd ask for a PR bond.
Okay. Attorney Anderson, does your client have reliable transportation?
I believe so, but I would need to ask him to confirm.
Yes, I have my driver's license. I have a vehicle.
Okay, so you've got a
Yes.
reliable vehicle. Okay, thank you.
Changed since the time of arrest, but my information at the time was that the license was not valid, but that may be different now.
It's my understanding that's been corrected.
It is valid.
Perfect, that makes sense, thank you.
Yep. And the probation's out of Genesee County?
7th Circuit, which I think is Genesee, but I'm not 100% sure. Yes, Genesee.
So, at this time, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. By the close of business on Monday, so close of business being 4 p.m., you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. The court will allow you to test closer to home, but you do need to report to community corrections that first time for an intake and to get set up and to sign whatever you need to sign. It may be a release of information so that they can communicate with wherever you're going in your county. Okay? Okay. And because you're on probation in Genesee County, if you're already testing through your probation, there may be something you should...
I am already.
Yeah, so there may be like a release of information or something you can do through that too. You should probably talk to your probation officer, talk to the public defender, okay? But they may be able to get the information to community corrections that way as well.
Okay.
So, but you do still need to go to community corrections that first time.
I will.
Okay, and you can make it by 4 p.m. on Monday?
Yes, ma'am.
Okay, so you are not to leave the state of Michigan without the court's permission. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court. The next one in this matter being that probable cause conference on August 28th. That also means going to community corrections, like I just said about 4 times. Okay? Okay. So,
I'm just trying to get all this put behind me. It's an old case.
yes. So, just do what we're telling you to do. Okay?
All right.
Okay. Do you understand all the conditions?
Yes, ma'am.
Okay. Any questions about any of them?
No, ma'am.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $15,000 personal recognizance bond. So what that means is you are not paying anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, a bench warrant can issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $15,000.
Okay.
Okay, so anything else from the attorneys?
No, Your Honor.
No, Your Honor.
Okay, thank you. Then, Mr. Cleaver, if you don't have any questions about anything I just said, you're free to go to the door and tell the jail that you're finished.
Okay. Is there any way possible I can get the information on where I need to go with? If they're gonna leave me with that on the way out the door?
They should give you paperwork on where to go before you leave. Okay, you should get paperwork for all of this before you
Okay.
leave.
Okay.
So, I will also tell you that Community Corrections is located basically in the same campus that you're in right now with the jail, okay? So when you are out of the jail, if you go up the hill from where you are right now, there's a building that's sitting up at the top of the hill, kind of a brown brick building. It's labeled Re-Entry Center. That's Community Corrections.
Okay, so I go there now or come back Monday and do it?
You can come back by 4 p.m. Monday. 'Cause
Okay.
I don't think they're probably open at this point.
Okay, thank you.
So, okay. If
Thank you, Judge. I really appreciate it.
Magistrate, but thank you, and you're free to go to the door.
Thank you.
And I believe that concludes our docket for today.
All right, see you tomorrow.
Bye-bye,
Yes.
everybody.
That hearing had a little bit of everything. Magistrate Hilary Braley presided over the arraignment of Waylon Cleaver, and what looked like a standard bond setting turned into a careful walkthrough of probation history, testing logistics, and some practical problem solving presented by the Public Defender's Office, waived a formal reading, and stood mute, while his attorney reserved bond argument. The magistrate explained his rights in plain detail: silence, jury trial, presumption of innocence, and then emphasized that because this was a felony, he'd also get a probable cause conference and potentially a preliminary exam. The prosecutor pressed for supervision at community corrections, noting that Cleaver had multiple prior drug-related felonies, was currently on probation for possession and resisting an officer, and now faced fresh possession charges. Her request was clear: at least weekly drug testing, if not more, with intermediate to high supervision. Defense counsel countered by asking for a personal bond, highlighting that Cleaver is a father of 4, that the charges stemmed from nearly a year ago, and that nothing else was holding him in custody. He also raised a practical issue. Cleaver lives in Mount Morris, so requiring him to report to Washtenaw County for every test would be burdensome. Cleaver himself was respectful and cooperative, confirming that he now had a valid license and reliable transportation, a change from when he was first arrested. Magistrate Braley listened carefully, and her solution was both firm and flexible. She ordered him to report to community corrections by 4 p.m. Monday for an intake, but allowed future testing to occur closer to home, so long as paperwork and information sharing were squared away. She reminded him to speak with his probation officer to ensure continuity, and clarified that failure to follow through would mean arrest on the spot if any officer found probable cause of a violation. The final order was a $15,000 personal recognizance bond with strict conditions: no alcohol, no marijuana, no illegal drugs, no leaving Michigan, no new offenses, and compliance with testing. Cleaver thanked the court, even asking politely how he'd received the paperwork he needed, and the magistrate directed him to the re-entry center up the hill from the jail. The courtroom atmosphere was calm, professional, and even a little supportive. Prosecution urging caution, defense pressing for practicality, and the magistrate keeping the process grounded in accountability while still leaving Cleaver a chance to succeed. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,